Code Enforcement Board hearing, May 26, 2021. We'll call it 6:35. Emily, could you please call roll?
Yes, Paul Hughes,
Present.
Benjamin Hartman,
Here.
Ariel Hernandez, George Sanchez,
Here.
Robert Gonzalez.
Present.
We'll do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Mr. Sanchez, we have a oath of office for you.
That's what I see on the agenda.
If you'd like to stand, and the town attorney will swear you in.
I'm going to just read the oath and then you can say I do if that's okay with you.
I will be.
If you would prefer, you can recite it.
No, I like what you're doing.
Do you solemnly swear or affirm that you will support, protect, and defend the Constitution and government of the United States and of the state of Florida, that you are duly qualified to hold office under the Constitution of the state, and that you will faithfully perform the duties of Code Enforcement Board member of the town of Lake Clark Shores, Florida, on which you are now about to enter, so help you God?
I do.
And then you'll need to sign the copy that's there in front of you and print your name and date it.
You got it.
And that'll become part of the official records of the town. It's required by our state constitution that any person serving in an official capacity in government must take an oath in support of the state and federal constitution. And all employees who receive public funds have to also sign an oath.
Thank you. It turns out that we need to appoint a vice chairman as the next order of business. Mr. Hartman, I think you have a lot of seniority. Would you be interested?
I would love the opportunity.
Are there anyone else?
The motion is seconded.
Oh, okay. I can't make the motion, so,
I'll make the motion.
okay,
And I'll second it.
okay. Any further discussion?
None at all.
All in favor, say aye.
Aye.
Is there anyone opposed?
Nay.
Motion carries.
I mean, no.
Welcome, Ben. Thank you.
Thank you.
Thank you for your volunteerism. Chair would entertain a motion to approve the agenda. Is
So moved.
there a second?
I second.
All those in favor, say aye.
Aye.
Anyone opposed? Motion carries. Next item of business is the consent agenda, which is the approval of the April 28th meeting minutes. Any unfinished cases now in compliance and any new cases in compliance. Dana, do we have any?
Yes, on the second page, top case 21-0122, Jeremy Mortarella. That one is placed in compliance.
Okay, that it?
Yes.
Okay. Chair would entertain a motion to approve the consent agenda.
So moved.
Is there a second?
I second.
All in favor, say aye.
Aye.
Anyone opposed? Motion carries. Next item of business is disclosure of visits, and we'll ask that if you have any firsthand knowledge of any of the cases coming up before us tonight, or have had any conversation with individuals in the town about any of the cases to come up before us tonight, please disclose that at the time of the on the agenda, and we'll go on. Anyone in here tonight that's going to be speaking to any of the cases, if you would please stand and be sworn in by the town attorney.
And just so you know and understand why, Florida law requires that at quasi judicial hearings, which are informal hearings, that the testimony has to be substantially competent testimony, and that's defined as sworn testimony. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Yeah, Dana, should we go in any particular order to hear?
Mrs. Martorella is here for her case, so you can hear her first.
Okay. That would be case number 21-0121. Dana,
I don't have any updated
Addition-
information. I think when, in the last meeting, Mr. Martorella requested for them to come to this meeting and give us an update. So that's what, she's here for her property.
ma'am, would you like to come up and
Sure.
give us any,
So I've never done
Welcome.
We'll have fun with it.
nothing to it.
this. Thank you. And I was here to represent my son Jeremy, but
He's
so you
good.
know,
Yep.
the roof was finished yesterday. He has a complete new roof.
Oh.
They did his, when I say they, the company did his house first because it had way more damage than mine.
Mhm.
So I was going to speak on that. I have pictures. I guess you don't need, not necessary.
Nope,
Okay, all right.
you're good. Thank you.
So for my home, which really doesn't look so good up there, the same company is coming Tuesday after Memorial Day to remove the tarp and begin the repairs.
That's terrific. Any questions?
No,
No,
I'd make a motion to continue testimony and evidence presented in case number 21-0121. I move that this board continue this matter until code enforcement board hearing on June 23rd, 2021.
I'll second that.
June 20th.
So that just basically means we'll
You'll
assume-
notify, I'll come back on June 20th.
we'll assume that it's all going to be taken care of by them. And in fact, you could probably check with Dana if it's going to be done Tuesday. It wouldn't be necessary for you to come back, I don't think, unless, as long as she says it's all taken care of.
Yeah, Jeremy will let me know and then I'll just tell him.
Okay.
I'll drive by and check because you have a tarp on the front and
And
the
one on
back.
the side and the back, yes.
Okay.
And that was your son here that was present at the last
The
meeting?
last meeting. he-
What a swell guy. He was
Yeah. Yeah.
an amazing gentleman.
Thank you so much. Single parent and I raised my son and I have a daughter. That's her white car,
Oh,
who's graduating June 19th. She'll have her BSN.
nice. Well,
Alright.
congratulations.
Thank you.
He's a
Thank
great
you for
individual.
coming and thank you for taking care of this.
Thank you so much. Thank you. I love Lake.
Have a great day.
Thank you.
We share your sentiment.
Yes, I do. Thank you so
You're welcome. Thank you. Have a good night. Thank you.
Okay, the next item we'll go to is continued cases. 21-0070. Patricia Rott?
I think we need to make a continue the 0122 case as well, correct?
Yeah,
Oh, it's in compliance.
No, it's-
So,
yeah,
sorry.
it's in compliance.
Dana,
Yes.
anything on,
Nope. She had told us that she would come back with an update.
okay, Ms. Rott?
So the last time I was here, you guys told me what I needed to do, so we did that. So I have the motion to compel mediation that was put in by the lawyer, the notice of the trial, and the upcoming hearing that is done, because we're fighting with the insurance company and have been. So I have, you guys asked me to get these documents, so I have them.
Are those for us?
Yes.
Oh, beautiful. Maybe the lawyer would like to.
And we should have a motion to receive and file those into evidence.
I'll make a motion to receive and file these items into evidence in regards to case 21-0070.
Is there a second?
I second.
All those in favor say aye.
Aye.
Anyone opposed? Motion carries.
And just so that the record reflects what I'm looking at, it's exactly what Ms. Rott was explaining. Plaintiff's motion to compel mediation, plaintiff's notice for trial, and notice of hearing. The most interesting is the plaintiff's motion to compel mediation was submitted to the court on May 6th of 2021, requesting that within 45 days, that the court enter an order compelling mediation within 45 days. So with that being said, I would be inclined to make a motion to continue, and based on testimony and evidence presented in case number 21-0070, I move that this board continue this matter until code enforcement board hearing on June 23rd. 2021.
I second it.
Okay. All those in favor of the motion, say aye.
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 Anyone opposed? Motion carries. So,
I'll see you again next month.
yeah, hopefully.
Hopefully
we
with
close.
positive things.
And Thank you for, it's incredible what the lawyer can do, just,
We didn't know what to ask, you know what I mean? So
Right.
When you told, I was like, what, just tell me what I asked for, and then they moved.
No,
That was very
absolutely.
helpful, so.
No, I'm impressed and I'm glad that they're moving forward. So it's nice to put some pressure on them and so that they can properly advocate for your rights.
Thank you.
Thank you for coming.
Thank
Now you
you.
can tell your mom that code enforcement's not always bad. I try to tell her. Thank you. You too.
Okay, moving on to continued cases, 21-0126, John Gigliotti, trustee of the John Gigliotti Trust. Dana, do we have any new information?
So I was gonna go knock on his door because I recall in the last meeting, he said he was gonna call me. That doesn't mean I could have messages over there. Sometimes people call at the last minute. So when I went to go knock on his door, I said, oh, okay, well, this answers my question. Because at the last meeting, he indicated, if I remember correctly, that it was all still there. He just cleared what we couldn't see. So yes, he cleaned up a significant amount, but that's what's left. And I was going there to talk about some other things too, because it didn't appear that he was moving on it. And so I was able to get a photo. And I never even knocked on the door. I just grabbed the photo because that answered my question. And I kind of was thinking that he would come to the meeting.
Not acceptable.
Well, in disclosure, I'll make the same disclosure I made at the last meeting. It's I know John, he's since passed and we're very, very sorry for that. But it's a house that I played in or played across his yard and I pass it every single day. Other than that, I haven't had any conversations. So I think that satisfies disclosure.
And he made it clear that he's going to be cleaning it up to sell the property. So
With
I mean-
that, I think that, we had given a 30 days and this is just kind of off the top of my head, we'd given 30 days prior, for the grieving process. And I know that that's, it is difficult and he has substantially cleaned up what you can see from the street.
right, because you cannot see that.
You can't see, it's obstructed by a lot of foliage. I'm not sure what the board, what action we want to take because it is not visible from the street.
No, but
What does the code actually say?
so I had written him for nuisance. Let me double check myself. 3420, yeah, it's under the nuisance and the open storage. I cited the definition. So to me, it's a nuisance. And he did give me access when I had went there originally, which I was hoping to work on that stuff separate. But when he was here last meeting, he had mentioned that he did not clean the entire porch up like we spoke about when I issued the hearing notice for the meeting last month. So that led me to believe that I could go and knock on his door to talk to him to find out where he was, and I could still see that all the stuff was still there. So it's still kind of it could be a nuisance because of the previous complaints. I have not gotten any in the last probably 30 days or more, but that's trash.
And
It's
if there
not storage. It's not like bikes and lawnmowers. It's trash that there's no value to it whatsoever. It's you drink a Gatorade and throw it on the porch. So it is a nuisance because it can harbor rats and who knows what else.
And if we had a storm, it would be all over. the neighborhood.
Oh, it'd be trash. It's a lot of trash. The picture doesn't do it.
Oh, no,
Any
we're coming up to hurricane season, right? Starting June 1st. But this has been a constant nuisance, right, in our community? This particular.
Well, he's not labeled repeat, so I don't know how I could really say,
And
answer that.
to narrow the issue here, I don't see that there's any, I don't know if we have an ordinance that prohibits or restricts trash, visible trash. And I just want to make sure that we're just narrowly focused on the open storage and that is
So
what it is.
That's why many, many meetings ago, Trent Swift had recommended that things like this be labeled as a nuisance.
Right.
So that's what section 3420 is, a nuisance. And if
Okay.
you want to read that specific ordinance and see if it still meets it, I kind of think it is, because it can be a nuisance. I don't know so much using hurricane season, but if a storm comes, it can blow all over someone's properties, and it's a significant amount of trash. So that could be a nuisance to somebody, as well as rats.
Could we have
And if I can read-
Charlie?
if
Yeah,
I-
please.
If I can read you the definition section, which is 3419, and this is one of the definitions under nuisance. The presence, accumulation, open storage, or otherwise keeping of any abandoned, discarded, or unused chattel. So I think that this clearly falls into that category. And then the actual violation is 3420, which says that it's unlawful for the person to keep the premises in that manner, and declares it to be a nuisance.
Okay. Well, I'd be prepared to make a motion if the board would want to hear. And I move that in case 21-0126, John Gigliotti, trustee of the John J. Gigliotti Trust, dated June 8th, 1992, at 7523 Pine Tree Lane, be found in violation of section 34-20, 34-19 sub 7, open storage and public view on the front porch, and that that a fine of $50 a day may be imposed unless the items are removed by the next meeting date of June 23rd.
Can I ask, could we really do 30, or should we honestly, this has obviously been a continuous issue, make it, what, by Tuesday? Can we just say, listen, you got, or a notice be sent, because why should we wait 30 days from our meeting? In the meantime, you got rats, you got, or
That's
possible
what you
storm.
guys normally do.
Right.
I'm just letting you
But-
know.
I like your idea.
I don't think, unfortunately, I know he's a brother, and I know they had a doubt. It just seems it just runs in the family. I guess their standard of cleanliness or whatever is different.
Not for nothing, they have maybe 15 empty garbage cans on the north side of the home. All you have to do, I don't know why it's such an issue, is move the garbage can to the front door, load them up, put them on the curb. It doesn't cost you any money, it just costs time.
I just think waiting 30 days in this particular case, I don't think this resident warrants it. I think we should cut it down and maybe send a notice to them and said, this needs to be cleared. If not, the $50, and the $50 will start from today. So if it's not cleared by a certain date, make it, I know it's Memorial Weekend. Maybe, I don't know if he's out of town. Would June 1st be unreasonable, or do you want to no more than a week? But even a week, I think is
I'm
is
okay
not
with
good.
that.
Well,
So-
Mr. Hartman's motion wasn't seconded yet, so Ben, if you'd like to
I'm happy to
adjust. your-
amend.
If you would allow discussion, if I may be heard
Yeah.
before we make a
Let
second
him-
on that. Normal notice, if we want to shorten it from 30 days to 20 days is the notice that we use in court if you get served with a complaint. And if we treat this as the violation, you essentially have 20 days to cure, 20 days to respond. So to keep things uniform with already established procedures, 20 days, that's what I would go for. It's not the tomorrow scenario, but I think the 20 days in light of what the family's going through would be fair. And you can't see it from the curb.
That would be June 18th.
So then Dana, Dana would go there on June 18th if you hear nothing from that point on, or what would?
Well, I'll go knock on his door tomorrow and let him know as a courtesy. I wouldn't want him to have to wait till we give him a
Right.
hearing notice, so.
The fine would still apply. We're still finding him in violation. The violation is still ongoing as of today. But in terms of getting this under compliance, and again, remember, the motion is for may be imposed, not will be imposed. So we can always revisit this later when we actually effectuate the fine.
But I'll go knock on his door and tell him face to face that, and explain it to him, because I don't know that he fully understands these things. This is not stuff that he normally deals with. But, so he doesn't have to wait for the
What
letter.
if we stated it this way, and just instead of may be imposed, say that a fine will be imposed beginning June 18th.
I'd say stay retroactive of
today?
today.
Because we can always go back and take it down once it comes into compliance.
Right. The key is creating urgency. And I
Okay.
think also if someone doesn't take care of something, and if that's the norm in our court and proceedings in the 20 days, even though I still think that's a little long, because I feel the rats and everything, because I know I got
Again,
rat boxes all
all
around
he
my house.
has to do is fill up the trash cans and put it on the curb.
No, I agree, but he hasn't done it.
That's all he has. Yeah, I don't
I
understand why.
understand, but I think it's just more of a creating, I feel, urgency in getting the matter resolved. And at the same time, they would realize, okay, I'll save a lot of money if I do something now, because if not, I'm gonna be paying the penalty, because he should have been here, right? He was told, hey, you've got a hearing, you're on there. He should be here right now.
He said he was gonna clean it all up, but I'm not, I don't know if something else happened in the family or if he got sick.
So he's aware that this is a no-no.
Oh, yeah, I was at the house for a little while when I issued the original hearing notice.
Gerard,
I walked
I
the
see what you're
entire
saying,
house
and
with them.
I see what you're saying, and you know, to create that urgency. So we want him to come into compliance as soon as possible, and then the fine occurs. Or do you want the fine from today and then?
We can whittle it down afterwards if he
Correct.
comes into compliance. I'm game for that. Let's find him not in compliance with a $50 a day fine being imposed as of today.
And must have it, yeah. And then what a date of, are we sticking with the 20 days or are we gonna?
No, if we impose the fine, he's not in compliance. When he comes into compliance, then we can discuss with him the fine and even take it down if we so choose.
I think it also gives him an opportunity to come back before the board and explain and give reasoning and you know, we're going to be amenable to whatever he's going through, but I think I agree with you guys.
I think Emily will need a specific motion.
All right, let's go at it from the top. You find that in case 21-0126, John Gigliotti, trustee of the John J. Gigliotti Trust, dated June 8th, 1992, at 7523 Pine Tree Lane, be found in violation of section 34-20, 34-19 sub 7, and that a fine of $50 a day beginning today be imposed.
Second the motion.
Any further discussion?
Are we putting a date on this? No?
No need.
No.
Okay.
So regardless, he has to come back to the next meeting and speak with you guys.
Correct.
Okay, I'll make him understand that.
Because you can always come back to us and tell us everything is just cleared up just fine. Hopefully. Any further discussion? All those in favor of the motion say aye.
Aye.
Is there anyone opposed? Motion carries. Okay. Next item of business is board comments, suggestions, updates. Anyone? Mr. Town Manager, anything for us? No? Doing a marvelous job. Charlie?
Just wanted to say that the issue of roofs is a big issue, not just with people who have tarps on their roofs, who have insurance claims, but because of the number of insurance claims. And you probably have heard some of the commercials of the companies that want to come out and inspect because they're going to find damage and try to file a claim. Now, when you sell your property, if your roof is still secure and not leaking, but aged, the insurance companies won't insure unless you re-roof.
Mhm.
So it's becoming a major issue and a big expense to property owners, because if you sell, you may have to replace your roof before it's time to replace your roof.
Wow.
No, I have a friend that they're already sending notices. They're basically trying to get rid of lease exposure and his roof reached the 20-year mark.
Yeah.
They send him a letter and cancel.
Yeah.
Right there. It's
That's
just,
what's happening.
They didn't even give him an opportunity to get a new roof.
that's just it. Well, that's it. They're trying to, take away exposure. but that's it. That's what the insurance, it's a big issue.
It's bad business.
And I'm in real estate, I'm in mortgages and I'm hearing it all the time. It is, and the rates are,
It's only going to get
Increasing.
worse.
yeah, we got an issue. It's something that I think there's a bill right now in the House with the state legislators. But it's a big problem
They've
in our
got
state.
to get rid of the assignment of benefits. And they've got to outlaw the ability for these contractors to solicit the way they are.
Yeah.
I'm closing a deal tomorrow at 515,000. Insurance is 15 grand and the roof is 4 years old.
Wow.
It's crazy. It's just out of control at this point.
I did want to make a mention. I took on a client, does not live in the neighborhood, but it was a plumbing company. And I know we have a lot of elderly folks in the town, and I'm kind of just utilizing this forum to make the town aware that there are companies that will come in. And to your point, this particular example was a water loss. A pipe had burst. And so a plumbing company now comes in, they bring in the mold mitigation, the fans, the whole entire thing. They assign the benefits. They're using iPads. The homeowner doesn't ever get a copy of it. This person didn't know what they were signing. One was a signature, others were like typed initials. It's very, very hard to actually see who is signing what. Long story short, they're engaging in the unlicensed practice of public adjusting. There was a liquidated damages clause. And so the entire damage of what they had estimated was approximately $100,000. Now, this particular person said, I don't necessarily agree with your practices, and I've never gotten any paperwork from you, and I don't choose to do business with you anymore. Well, that's when they turned around and said, well, you owe us 15 or 20% of what's called liquidated damages. And so now that's spurring additional litigation from contractor to homeowner, in addition to the litigation that's happening between homeowners and insurance companies. So just, I don't know if there's a way that we can have kind of a PSA and let people know, be careful with contractors and be careful with what you sign.
We can make it a little simpler. We can ask Eliza to put something in the next newsletter or something online that just says, before you hire a contractor, make sure they're registered with town.
Sure. Is the town looking into what documents or what contracts are being, do we have a copy of their contract?
When you pull permits, it's all part of the process. Yeah.
Okay.
The only thing though is that I'm not sure, and Charlie maybe can answer that question. There's a bill that I think is going to restrict us from registration. And also there's also a bill that says that we can't require a copy of the contract to issue a building permit.
Yeah. And I don't know what
Why?
There's an old expression, when the legislature's in session, keep your shotgun loaded and your horse saddled. And
So
that's
then when
what
they
we're
pull a
facing.
permit, how do you prove the?
I don't know. I don't know how much we're gonna be able to
wow.
charge, because people are gonna just put whatever amount they want. I don't know. We'll have to figure it out.
I know a lot of people do the owner builder permits here.
Yeah.
All right, folks. Story for another day.
If there's no further comments, the chair would entertain a motion to adjourn.
Second.
So moved.
All in favor?
Aye.
Aye. Thank you. Meeting adjourned.
Thank you.
Thank you.
I'll look at
I say we're a pretty efficient